Okay, good evening. My name is Cameron Irwin, and I'm going to be discussing the use of unmanned aerial systems in the domestic United States. So the increased use of unmanned aerial systems, or drones as you may know them, in the United States by police departments, commercial companies, and private individuals has caused the outcry of privacy concerns over what they are surveilling. This brings me to my main claim. The use of domestic unmanned aerial systems fails to affect the personal privacy of individuals. My two supporting claims are: first, domestic unmanned aerial systems have the same functionality to police departments as their current helicopters, and secondly, domestic unmanned aerial systems operators have to abide by current privacy laws. So let's get started. Number one, domestic unmanned aerial systems, which I'm just going to call drones from now on so I don't waste my whole time repeating that word, have the same functionality to police departments as their current helicopters. In an article from Privacy by Design, they stated a U.S. Supreme Court ruling from 1986 that claimed video surveillance from police aircraft where they observed a marijuana plant in a backyard did not constitute a search because the observation was made from public airspace. However, in 2001, using a thermal imaging device from a public vantage point, the radiant heat from a person's home was constituted as a search and thus needed a warrant to be used. So both video devices and thermal imaging are used on police helicopters, whether they're gathering information about suspects or during operations. The same process can be used for drones. In the year 2010, in an article from the Washington Post, they described the first use of a drone by a local law enforcement agency in Texas. As a high-risk operation, they used the drone to provide video to their men on the ground doing the raid. They had to get authorization to use this, and it set a precedent to use authorization and get a warrant before using this drone. This drone had similar equipment that their common police helicopter would have, so it fall under the same precedents that were set under that helicopter. My second claim is that domestic unmanned aerial systems operators have to abide by current privacy laws. So the Brookings Institute talks about privacy in drones, and the way they discuss it is they talk about trespassing on someone's private property. Generally that'd be walking on it. You could equate that to about the same as flying a drone at a low level. Other privacy issues also include stalking somebody, intruding upon their personal domicile, and publishing private facts about that person. So I'm sure you're familiar with Google Street View. It's a service that takes videos of a street, which is a public place, and oftentimes you see homes in the background. Those homes are obviously a private place. In an article from the New York Times, they discuss a lady who lives in San Francisco who saw her house on Google Street View, and in it she saw her cat and felt that was an invasion of her privacy. One of their consulting firms specializing in mapping and imagery stated that the people in public spaces can be photographed, and since the photograph from Google Street View was taken in a public place, that it was perfectly legal and not violating any privacy laws. The same sort of thing can be applied to unmanned aerial systems because they're taking pictures over private areas. If that area happens to be someone's home, they're hopefully not intruding on that person and hopefully not breaking any laws. In an article from Business Insider, a woman in Seattle was getting ready in the morning. She looked out her window and saw a drone flying there. She panicked, thinking it was like a peeping Tom situation, and called the front desk, who then called the police. And then the next day, the man flying the drone saw the article in the newspaper, called the police, turned himself in, and explained to both the police and her that he was not taking video or pictures of her, but he was actually filming for a customer the Seattle skyline, and at no time was his drone pointed at her window, let alone her building. He wanted to state that if I were to point at someone's window, I'd have to be within a few feet to see anything. He also explains that privacy has a lot to do with intent, and we weren't intending to pry on anyone. So an unmanned aerial system can take pictures over a public area that may include private areas, but it does not necessarily infringe on that individuals' personal privacy. So to summarize, the use of domestic unmanned aerial systems fails to affect personal privacy because for the use in police use, it has the same functionality as their police helicopters do currently. And then for commercial and individual use, it follows under the current privacy laws that are already in place. Thank you.
All right, Cameron, I think you identify the proposition clearly. You explained a little bit about what the controversy is. I think you could probably develop that more. That it is a technological innovation that's substantially different, and the frequency with which people might be encountering drones, whether they be used by authorities or somebody else, I think is likely to escalate, and that's probably why there's more discussion of this issue, and I think a little more background there would be helpful. But you did a good job identifying the proposition. It's clearly stated, and you have the two secondary claims identified. The phrasing on them is a little complicated. I do think that it's pretty clear that your first inference is that we have relatively existing standards that are applicable in this situation. You just basically kind of make the analogy to the police helicopters. And then on the second point, you say that there are laws that apply in these particular areas already. So I thought that you did a good job explaining what those laws were and explaining the comparison that you were talking about, for the most part from a legal point of view, although you also acknowledge in the argument that there are in the second point especially, that there are places where people might be concerned with stalking issues or, for instance, the peeping Tom kind of thing. The analogy to Google is an interesting one from a legal point of view. I'm not exactly sure that it addresses the privacy issue, and you do have an argument there that talks about intent being a key point, and I'm wondering if that's a legal standard or if that's the explanation of the guy who was flying the drone there in Seattle, and he just didn't think that it would meet that legal standard. So if there is a legal standard, I think a clear citation on that would be helpful. The court ruling from 1986 I thought was pretty effective. There's a comparison, I think, with the radiant heat requirement versus, we're looking, that's okay, but if we got radiant heat, that's intrusive. If that's a court ruling, I feel good as long as the drones don't have radiant heat, that I'm good to go. I'm not exactly sure I'm still comfortable with, everybody in the neighborhood flying their drone around my backyard. But I understand the point that you're making there. The example of Texas, I thought, was a good illustration of how that point could be addressed from a legal point of view. But that's, of course, only from official use of drones, and I'm sure that some of the concerns will be outside of that category. I think there might be a little bit more argument about, like, FAA regulations with drones and that sort of thing, and whether or not they would be intrusive or available or affecting people in the kind of ways that people are afraid of, because there are other rules about flying them that would have to apply also. And so that feels like a point that could be added to the argument to strengthen your position, not from the legal, kind of from a different legal point of view that would address that issue. And I thought you did a nice job presenting it in pretty reasonable generalizations. All right, thank you.